Thank you for investing your time to watch this video. I don't think it comes as a surprise to any of you that there is a new real estate act pending. It's called the Trust in Real Estate Services Act. And it's coming out in kind of stages. The first phase is already in place, and that's what's allowed you to have personal real estate corporations. And there's a number of other things, and some of the things we already know about. We know that there will no longer be a category called customer. What it'll be is self-representative individuals. Now, I don't think the people who are drafting this legislation have thought this through, because you have the right, if you want, to draft an offer for somebody who's self-represented. They know that they wouldn't know how to do it. And so you can draft an offer. You can show them a property if it's your listing. But the thing is, if you're drafting them an offer, how are you going to do that without them, to a certain extent, relying on you, or to a certain extent, you giving them some advice about whether there should be an escape clause, this sort of thing. And as soon as you do that, there's implied agency. So I don't think they've thought that through. But that's really not what I want to talk about today. What I want to talk about is encapsulated in the title. It's a trust in real estate services. And what they're suggesting is that everything in the Act, or a lot of what's in the Act, is going to be in place so that the consumer can trust what he's getting into when he signs a contract, whether it's a buyer representation agreement or whether it's a listing agreement. So one of the things you need to watch for in this coming Act, and I'm not wanting to spend all my time on the Act, but by way of background, is detailed description of your services when you enter into a contract. It isn't enough to say, I'm going to use my best efforts to try and sell your house. No, it's going to be, I'm going to be doing open houses, what days, what times, how often. I'm going to be marketing on social media, which media, how are you going to do it? And they want to give explanations specific about what you're going to do. One of the things that's going to help is it's going to clamp down on people who overpromise and underdeliver. And certainly that happens a lot in life and business, and we all feel burned when that happens. And so does the consumer. And so the real estate agent says, you know, I'll sell your property and I'll guarantee this and I'll do that. They're going to say, well, you can put it down specifically what you're going to do, the promises you're going to make. So that's another thing. But then the other thing that I want to zero in on today is they're going to expect you to go a second mile, if you were, in ascertaining facts, the facts about the property. It's got to be accurate. You've got to be right. You've got to dig out latent defects if they're known by the seller. And the other thing that is kind of, it's been there, but they're going to be zeroing down on, you're going to be hearing a lot more about in the new Act, is material facts. And that is facts that could affect a person's decision to buy or sell, and the facts that could affect a person's decision as to how much he's going to pay or what price he's going to take. So these aren't latent defects, but they still have to be uncovered and in certain circumstances have to be disclosed. And that brings me to what I want to talk about very briefly today, and that's the residential information checklist. For years and years, we used to use a seller property information statement. And that was a fairly exhaustive questionnaire we went through with the seller to find out exactly as much background as we could about his property. We wanted to find out about general information. We wanted to find out about environmental issues. Is there an oil tank buried somewhere? We want to find out about structural issues and changes that have been made to the property. And so we used a seller property information statement to do that. And it was an excellent form. The lawyers didn't like it. The reason they didn't like it is they said, we are making available patent defects, and that should be buyer beware. We shouldn't have to tell it. Well, the problem is material fact is halfway between a latent defect and a patent defect. And there's some obligations to tell people about these things, and certainly to know about them. How would we know about a latent defect if the seller doesn't tell us, if we don't ask the question? And so we go to those specific things and we ask the question. But the thing is, because of the resistance to the seller property information statement, AREA came up with the residential information checklist, which is Form 820, and it was the same thing. It asks general information, it asks environmental information, it asks structural and changes, modifications to the property information, and you go through the same questions, you write down the same information, but you don't publish it. It isn't available to the buyer, it isn't noted on the listing that it exists. But the thing is, you ask the questions, and maybe the seller never thought about bringing it to your attention, but it's a latent defect. You need to know. Maybe it's a material fact that could have an impact on the marketing, and you bring it to the light by asking the question. And it's really imperative that you do that. There was a situation not that long ago where a person listed a property and they put down laminate flooring. They found out that one of the spouses called them and said, "You've got that wrong. It's hardwood flooring." And because they had it wrong, they corrected it. They corrected it within 3 days. But RICO got a complaint about it, even though nobody put in an offer based on the wrong information. I think the person was fined $10,000. You're going to find that RICO, under the new act, is going to really double down on mistakes, errors, because they say you got an obligation to disclose, you got an obligation to discover, you got an obligation to be accurate about material facts. So what I want you to do moving forward from now on, get in the habit every time you take a listing, use one of the 820 forms, the Residential Information Checklist, and you'll be a step ahead of the game when it comes to the Trust and Real Estate Services Act. Thanks very much. Talk to you again next week.